Yung subtopic ay dissolution. Number 1. A corporation formed or organized under the provisions of the Corporation Code may be dissolved voluntarily or involuntarily. Yung voluntarily, the initiative comes from the corporation itself. Ayaw niya nang mag-continue. Gusto niya nang magpapadissolve. Yung involuntary, baka gusto niya pang mag-continue, pero hindi na pwede. Dahil baka pinahinto na siya ng SEC or pinahinto siya ng court for certain violations. Number 2, voluntary dissolution. Letter A, voluntary dissolution where no creditors are affected. No creditors are affected. The dissolution may be effected by majority vote of the board. Majority vote of the board. And by resolution adopted by affirmative vote of the majority of the OCS or majority of the members at a meeting called for the purpose. So yung voting requirement, majority of the board and majority of OCS or members. Majority. A verified request for dissolution, so magfa-file ng request for dissolution, shall be filed with the SEC. Within 15 days from receipt of the verified request for dissolution, the SEC shall approve the request and issue the certificate of dissolution. The dissolution shall take effect only upon the issuance by the SEC of a certificate of dissolution. So, kailangan merong certificate of dissolution. Next page. Letter B. Voluntary dissolution where creditors are affected. Creditors are affected. Medyo mahabang proseso to. A verified petition for dissolution. Kanina request for dissolution, dito petition for dissolution shall be filed with the SEC, signed by majority of the board. Majority of the board. And verified by the President or Corporate Secretary. The dissolution must be approved by 2/3 of OCS or 2/3 of the members at a meeting called for the purpose. So, iba yung voting requirement dito compared kanina. Majority of the board and 2/3 of OCS or members. Kanina, majority of the board and majority of OCS or members. The SEC shall issue an order fixing a deadline for filing objections. So, creditors would be affected dito. So, baka magfa-file sila ng objections to the petition which shall not be less than 30 days nor more than 60 days after the entry of the order. The copy of the order shall be published. So, merong publication at least once a week for 3 consecutive weeks in a newspaper of general circulation published in the city or municipality where the principal office of the corporation is located. Or if there is none, in a newspaper of general circulation in the Philippines. A similar copy should be posted. So, kanina publication, dito merong postings. For 3 consecutive weeks in 3 public places in such municipality or city. After 5 days notice given after the date on which a right to file objection has expired, the SEC shall proceed to hear the petition. So, merong hearing. If no objection is sufficient and material allegations of the petition are true, the SEC shall render judgment dissolving the corporation. So, merong judgment. Merong hearing kasi, so merong judgment or decision dissolving the corporation. The dissolution shall take effect only upon the issuance by the SEC of a certificate of dissolution. So, dapat merong certificate of dissolution din. Next page. Letter C, dissolution by shortening the corporate term. Ito yung mas simple na approach na i-amend mo lang yung articles mo, shortening the corporate term. That's it. Walang or hindi kailangan yung certificate of dissolution dito. Amending the articles of incorporation to shorten the corporate term pursuant to the provisions of the Corporation Code. Upon the expiration of the shortened term, as stated in the approved amended articles of incorporation, the corporation shall be deemed dissolved, automatic, without any further proceedings. In case of the expiration of corporate term, dissolution shall automatically take effect on the day following the last day of the corporate term stated in the article. So, shall automatically take effect without need for issuance of certificate of dissolution. So, hindi kailangan yung certificate of dissolution. Number 3, involuntary dissolution. A corporation may be dissolved by the SEC motu proprio. Ano ibig sabihin ng motu proprio? On its own initiative. On its own initiative. Kahit walang complaint. Or upon filing of a verified complaint. So, upon filing of a verified complaint by any interested party. The following may be grounds for dissolution of the corporation. Letter A, non-use of corporate charter na discussed to under the incorporation na topic. If a corporation does not formally organize and commence its business within 5 years from the date of its incorporation, its certificate of incorporation shall be deemed revoked, automatic, as of the day following the end of the 5-year period. Meron siyang certificate of incorporation pero hindi nag-organize at hindi nag-commence business within 5 years from the date of its incorporation. Automatic, marirevoke. Letter B, continuous operation or continuous in operation of a corporation. Na-discuss din to sa incorporation na topic. Ito, mayroong certificate of incorporation, nag-organize, nag-do business, pero huminto. If a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years. 5 consecutive years. The SEC may, next page, after due notice and hearing, place the corporation under delinquent status. So, hindi na re-revoke yung kanyang certificate of incorporation. The corporation has 2 years, so binibigyan pa siya ng chance to resume operations. Letter C. Upon receipt of a lawful court order dissolving the corporation. Letter D, upon finding by final judgment that the corporation procured its incorporation through fraud. Letter E, upon finding by final judgment that the corporation was created for the purpose of committing, concealing, or aiding the commission of securities violations, smuggling, tax evasion, money laundering, or graft and corrupt practices. Yung next item, committed or aided in the commission of the above-mentioned violations. Yung kanina, created for the purpose of committing. Dito sa second item, committed or aided in the commission. Third item, repeatedly and knowingly tolerated. Repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. That ends dissolution, and that also ends Part 5 of Corporation Law Review.